Now before the court is Kennebec 24-125, State of Maine versus Aaron Engroff. Counsel are present. If you would identify yourselves by saying your names for the record, starting with appellant.
Good afternoon, Rory McNamara for the appellant, Aaron Engroff.
Good afternoon, Shannon Flaherty for the State of Maine.
Thank you. We are being streamed live on the web, I think. Okay. And do we have working lights now? Yes. Perfect. Okay, with that then, Attorney McNamara, if you'd like to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, counsel. As far as I can tell, this case is the first to reach the court in which a lack of a speedy trial caused actual detriment to a defendant's defense. Because of the blitz, because of more pressing cases, and because of insufficient resources.
Is the actual detriment, since you let the green light be on right away, is the actual detriment, when you say that, the admission of the CAC interview?
I think that's one.
Because of the change, the enactment of the statute in the intervening time?
Yeah, that's the biggest component, I would say. Of
What other actual prejudice is there?
Some of the more quotidian forms, I guess, if you will, of he had to have a chaperone with, and he still does, with his own children. He lost his military career.
So there were effects. I mean, what I hear you saying is there were effects on him, but the timing issue is really, and I'm not, I don't mean to minimize those effects.
Right. Specific to the trial. I understand now. I'm sorry. In addition to the CAC video, the prosecutor made an argument that says that memory is a fickle thing, indicating that, well, that's something that those inconsistencies perhaps in the testimony or in the evidence, well, that's something that we're.
And that's highlighted in this case because of the
delay.
Real letters and things like that, that the memory was clearly.
Right. And the CAC interview in this case was taken 2 years before the trial. In the age of a child, that is quite a significant chunk of time and then to have the ability to go back and to watch as a child your video.
But doesn't that also equally to some extent, to your benefit? In other words, the length of time and the fading of memory and all is like, isn't that really help you argue that it's not reliable?
I think maybe in some cases it could. It wasn't a strategy that was chosen in this case, wasn't one that was pursued.
But that's a strategic issue.
Certainly, but I think there are always going to be reasons for why a defense is or isn't chosen. And in some cases, across the board, if we're thinking about other cases, I don't know whether that inures to defendants or not. Here.
Should we look at, when we're looking at factors, should we follow or depart from the federal factors, being length of delay, reason for delay, defendant's assertion of the right, and prejudice? Are there other factors that we should look at under a Maine constitutional analysis?
I think, as from the Winchester decision, certainly the Norris decision, as I see Justice Connors looking at you askance, I think she wrote the Winchester one. I think we know what
Askance?
I don't mean to mischaracterize if that wasn't askance.
I've never been askanced before.
The main factors are very similar to the federal ones. There may be some nuances difference, and I don't think in either federal jurisprudence or state jurisprudence as to the Constitution that it's necessarily limited to those three factors. There may be other things.
Well, so my question would be, when you talk about prejudice, I think we previously have identified it in Winchester: incarceration, adverse publicity, anxiety, and concern, as well as impairment of the defense. What I hear you doing is identifying that there are other factors, in other words, even short of incarceration, that in this case, the period of time that he was on bail was challenging more so than sometimes because of the inability to see children, the loss of the armed services position,
inability to find a job,
and other significant restraints on his movement or freedom.
Right, and I do think that that is something that, if I'm recalling the Winchester decision, is cognizable as a speedy trial form of
So
delay.
it's not just incarcerated or not, that the
Correct.
amount of restraint on freedom, even if bailed, would be relevant?
Correct, I think that's something that is relevant, and those are well articulated.
Is your argument, counsel, that the trial judge made erroneous findings or conclusions with respect to the factors, or that the factors that she added up amount to an abuse of discretion on her part?
And there's always going to be a gray area there, so bear with me as I answer that. I think as to the factors, we largely will as to the findings, we largely defer to those. But this difficult area in between is there prejudice via the CAC video? Excuse me. And I think there's some difficulty in this case because Justice Lopez, who heard the speedy trial motion, didn't know that the CAC video would be considered. So I think to the extent that's a finding, that's not prejudicial over there, I think there's a problem there. Justice Lopez didn't know that was coming in. This court certainly does and should not defer to any to the extent that's a finding. I think above that, it's actually a conclusion of law to determine whether or not that's prejudicial over there, and the same would go to the judge's consideration of the inability to hold a date certain trial.
Well, I was going to ask you about that. So the judge, Lopez below, held the period from October 23rd to January 24 when a date certain wasn't given to the defendant against the defendant. Isn't that just a scheduling issue like the other scheduling issues?
I don't think so. And I think
Okay.
the reason
So you're okay
why-
having that held against the defendant?
Oh, I'm sorry, maybe I misconstrued the question. Thank you for clarifying. I must have,
To my surprise.
I'm so used to saying
Mr.
no to
McNamara, you
everything
don't
we
usually
say.
get in so easily.
I'm sorry, I misheard the question.
I'm just, the period of October 23rd to January 24, the judge held that against the defendant in the analysis of the cause for the delay. Isn't that really a scheduling issue, just like the period from June to October?
It is. It's a scheduling requirement that should be counted, I don't want to say against the state, big state of Maine, if you will.
Against the court?
Right, against the court, the legislature and the executive branch, if we're honest. And the reason is, the very definition of a judicial system is a forum to which people come to litigate their dispute. It's an essential thing to be able to have date certain trials. We can't have corporate officers lined up in the hallway or out-of-state witnesses lined up in the hallway for weeks on end waiting to have a trial.
Was the request in this case for date certain or for special assignment?
For a date certain,
That's
Your
what I
Honor. So back to Justice Douglas's question about whether these are findings or conclusions, I tend to think these are conclusions about what, as a matter of law, is proper prejudice, what, in the matter of law, counts as a delay caused by the defendant, and they're not so much findings. But even if they are findings, there is this question of who made the findings and were they able to consider.
Well, let's say the defendant requested a date certain for trial on the date of the indictment.
Mm-hmm.
Does everything after that request get counted against the court and the state?
Yes, I think it must. I think that's the job of the courts, is to be able to litigate a case where the witnesses will come and be able to be convene and testify as to compulsory process. And certainly, I understand that there are difficulties in the Maine judicial system providing that right now. But I do think that if we take a step back, everyone here in this room recognizes that's something that the courts do need to be able to provide.
Well, there was, I think we can all agree, there was a big backlog that was in part caused by COVID. Mm-hmm. So how should we acknowledge, if in any way, any of the impacts of COVID? It's not really the state's fault that there was a pandemic.
Certainly not the state's fault that there was a pandemic. The backlog at this point was over 2 years old by the time defendant was indicted. And it was coming up on, if I've done the math, 3 years by the time it would have been 4 years by the time trial was ensuing. And at some point, when we have findings from the National Center for States Court that for the intake caseload of this judicial system, we're lacking 9 judges, then the legislature, the executive, has simply not fulfilled the duty, the obligation to provide for timely processing of these cases. I think it being so far after the fact that I don't think that that's a serious.
And the interview argument is basically, if we had had a speedier trial, this bad evidence against me wouldn't have been admitted. Is that really a good reason to say that you should count it against the state?
Well, I just disagree with your characterization, of course. I think that I would put it as the excusal of the complainant from testifying at trial, which we all know from our experience is often a situation where there's uneven testimony, there are inconsistencies, there are holes in credibility that can only be elicited on the stand and can only be developed on the stand, as opposed to a video camera up in the perch of a room with a girl with a hat on.
But there was the ability to cross and ask all those questions.
I don't think that's adequate, and I don't think that's adequate for constitutional reasons, as Your Honor knows, but it's a form of prejudice. If you ask defense counsel what is oftentimes the only defense, is to sit back and see if the complainant can make credible allegations in the solemn circumstances of a courtroom, as we have always required. And oftentimes that burden is simply not carried. And to fundamentally change that game, when defendant had asked for that, in contemplation of this, when the legislature passed that bill or was processing that bill in the spring, I think defense counsel became alert to it and said, oh my God, that's a potential threat to my client. Let's hurry up and have a trial. We need this trial before this becomes effective. And then was perhaps relying for a while on the fact that the state didn't indicate until 2 days before jury selection that it was in fact going to proceed under the statute. And that's where the prejudice comes in. In addition to the fundamental changing of the game, defense counsel didn't vet adequately that CAC video, as he said candidly several times, to know the reliability of the examiner, to know what techniques, what protocols may not have been followed. And that wasn't done because he didn't know until the last minute that was coming in. So that's all part of the prejudice. We haven't discussed the role of Rule 48B here. And I do think that that's, based off this court's case law, slightly different. And I just want to mention the 2 ways. It seems to be different. If I may just mention these 2 ways.
Quickly.
All right. There's no invocation requirement that I know of. And specifically, explicitly, it is a goal of 48B to ease court congestion, which it seems like exactly these circumstances. Thank you.
Thank you, counsel. Attorney Flaherty.
May it please the court. This court should affirm the trial court's legal findings and the jury's verdict for the following reasons. First, the trial court properly denied the defendant's motion to dismiss based on speedy trial grounds after weighing the necessary factors pursuant to the rules of criminal procedure, case law, and constitutional jurisprudence. Second, the defendant's right up to confrontation was not infringed because the defendant was able to cross-examine the child victim, the very definition of confrontation. Third, the trial court did not err in admitting the victim's statement pursuant to Section 358, as the statute created an exception to the rule of hearsay, a procedural evidentiary rule that applies at the time the trial occurs. And finally, even if this court were to find that the trial court erred in admitting Section 358 under the original version admitting the victim's statement, such error was harmless and the conviction should be affirmed. And I'm ready for questions if the court has them.
I'm going to go over to the speedy trial issue again. First, I want to ask you a similar question to what I asked Mr. McNamara. Do you agree that when we start talking about the effect on the defendant, in other words, we identified incarceration, but that the greater restraint, some bail conditions are more, have greater restriction on liberty than others. Do you agree that's a factor? It may not amount to incarceration, But being on PR bail with no conditions is a different ballgame than being on cash bail with a lot of significant restrictions.
I do agree, and I also think it also fits into the second part of that, where it talks about, the public, people being aware of it. I think it fits a little bit into both. And it's true, some bail conditions, you're just not supposed to commit new criminal crimes. Sometimes you're on house arrest. So I think that is a fair consideration the court can take.
And then secondly, I'm going to go back to the same question I asked about the period from October 23 to January 24, in asking for a date certain, as opposed to a special assignment. Isn't that really a court scheduling matter? And I understand it's not the state in the sense of the district attorney's office, so I'm clear on that. But isn't that really an issue of scheduling just as much as not getting it done during the Blitz or October? Or?
I think traditionally, yes, but in this case, a little bit different because of how many times the defendant himself asked for continuances. So the difference in this case than potentially just pure scheduling issues is that originally this case was indicted in early 2023.
But he didn't move to continue this. I mean, he just said, I need a date certain.
Every single time the case was set for a trial date, he said he wasn't ready. And that's the state's perspective. He needs special, specific trial dates for his out-of-court witnesses. And while I understand the difficulty of out-of-state witnesses.
Back up, though. I mean,
Okay.
needing a date certain, whether it's for out-of-state witnesses, experts, or the other kinds of things that happen, just even sometimes just the number of witnesses, is different than not being ready for trial.
I think that's fair to say. Maybe that's not the correct way to phrase it. But what I would say is that this is not a situation where there was one time where he asked for date specific and then the court adhered to that and then we went to trial. This happened 3 or 4 times.
And the court wouldn't give him a date specific.
But the court couldn't give them that. They couldn't give the ability to have, and that's.
But isn't that a question of, again, court scheduling?
I think it could be possibly weighed against court scheduling. I think the court is aware that that is weighed less heavily in the Winchester analysis.
And I understand that,
Right.
so.
But from the state's perspective still, and maybe I don't totally agree with Your Honor, is that in many ways it is a continuance. And I understand that it might be because of a scheduling issue, but in this case with the defense counsel at trial, there was originally a motion for bill of particulars, and then there was a waiver. That waiver happened in April of 2023, and then he reasserted the right to speedy trial in June. And Justice Lopez, as is in the appendix during that docket call, made it very clear, like, we can go if you're ready, and he wasn't ready. He did change the way he phrased it, but he wanted specially set dates for out-of-court witnesses or out-of-state witnesses. And then when he was told that we can't do that for this particular docket, he didn't necessarily, from the state's perspective, prepare. And what I mean by that, is it inconvenient for a person to be on call for a month? Yes. The state deals with that all the time. But you're going to subpoena someone for the entire month, and then eventually you will get those dates specific. So just because it's a little bit more difficult, I don't think that rises to a constitutional violation to the right to a speedy trial, especially when it's the defendant.
Well, that doesn't in and of itself, and I'm not suggesting. I mean, I guess I'm just trying to figure out how we count the time. And then the second follow-up question to that was, let's say I think that that's a scheduling issue. What do we do with the finding by Justice Lopez that it should be found against the defendant?
I think the court has to do an abuse of discretion analysis and see if she went above and beyond what was in the evidentiary record, and if her finding, even if it's under a clear convincing evidence standard, is it so beyond the evidence that she had before it that she made a completely erroneous decision. I don't think so. I think if you look at how she articulated it very clearly in that particular diatribe when she gave her oral argument or her oral findings.
Diatribe?
I know, that was a weird word, and I tried to fix it.
Kind of the wrong word.
It was a weird word, and then I tried to fix it quickly, but sometimes, you just get, tricked up. But during her oral findings, she clearly articulated, which is the better word, that she was weighing against the defendant because of how many times he was told we couldn't give specially set dates, and he continued to ask for them. And I do think that he could have been prepared if he had wanted to at that point.
So let me ask about the invocation. In Winchester, we said, for the Maine Constitution, that's really important. And the defendant says, well, but does that mean the time before the invocation doesn't get counted at all? That wouldn't make sense, would it? Do you agree that when we're looking at the first issue, the time of the delay, it doesn't matter when the defendant has invoked. The key is that they did invoke and indicated they wanted a speedy trial at some point.
I think that's fair, and it kind of goes into part of the argument that I had made about the sword and the shield of the waiver. But to answer your question first, I don't think it's fair if someone doesn't, if they have multiple attorneys and they decide not to assert their right until 14 months in, that entire 14 months gets deleted. But I do think it's important that the assertion be made. The issue that I had in this particular case is it seemed as if the speedy trial right was being used as both a sword and a shield for the defendant's purposes, in the fact that he would waive it and then reassert it. At times, it seemed convenient for
Well,
him.
did he waive or just agree it could be told for a period of time? I mean, there's a little bit of a difference.
He specifically, defense counsel specifically stated in June of 2023 that he had waived speedy trial in April of 2023, and that in June he was reasserting it. I believe Justice Murphy later on in one of the following arguments, because this was argued several times, said that she believed it could be considered tolling, maybe even in the original waiver back in April, she said it would toll. But the difficulty, and I think that appellant counsel mentioned this, and your honors know as former justices, is that the trial docket,
Actually, we're still justices.
sorry, I said trial, but the trial docket is insane. It's a very busy, ever-moving piece of everything. It's always changing. So the idea that you can waive speedy trial right and then reassert it and be on the exact next docket call, I think is not realistic. It's not something that can happen on a regular and ongoing basis. So the ability to waive your right to speedy trial when it's convenient for you because you're doing more research or more investigation and then reassert it isn't fundamentally fair.
So you've referred several times to the realistic ability to manage our trial dockets.
Yes.
And obviously, and I think this is what you were saying, as many of us know that firsthand.
Yes.
But isn't that a problem? I mean, isn't the whole idea of a right to speedy trial is that the fact that we as a judicial branch are unable to accommodate all the trials that need to be held is still, doesn't mean it's not a violation of the speedy trial.
I'm never going to get up here and say that we're not having trials as much as we should, because we're not, and I agree with that. I think that we have to look at this case very specifically, and you have to make a very case factual-based analysis. This is not a situation where at every docket call that Mr. Engroff appeared at with his defense counsel, he said, I'm ready to go at this docket call on any dates you give me. Every single time he was given that opportunity, even months in advance, specifically if you were to look at the October letter in the appendix that Mr. Bowe had sent, he was told you have, this is going to be December for potential January trial dates, without even attempting to find a way to make that date work after needing a speedy trial, asserting it over and over again. He said, that's not going to work for me again. That's not something that rises to a constitutional violation. When you're given the opportunity for a trial over and over again and it doesn't work for you, that's not a speedy trial violation from my perspective.
Let's go to the prejudice issue, because under the federal and the state, it's considered the most important issue.
Yes.
What's your response to his claim that if I had had this done earlier, this CAC interview wouldn't have come in?
The way that I remember when we were arguing this and when I was reminded in the brief, it was this idea that the CAC interview would never come in without this new statute, and that's just not true. Under State v. Adams, this court has found there are other rules of hearsay where the CAC interview could have come in different formats and different ways.
But isn't that important that those are different formats in different ways, and it is dependent on how the direct testimony of this alleged victim would unfold? And in this case, the advantage to the state of the CAC interview is, of course, you basically don't have to do it direct, other than, is that what happened? Yes, it is. And so you may have gotten in some, not necessarily all, of the CAC interview, but you may not have, depending on how the testimony went.
That's completely fair, but I would twist that around a little bit. The state's prepared, but so is the defendant. From the beginning of this case, that CAC interview was in share file in discovery. He had had it from the inception. He knew what she had alleged in that CAC interview. The idea that he was unprepared for what her allegations were because she didn't do a robust enough direct, from the state's perspective, is not logical, because you had the CAC interview from the very beginning. There was never a bait and switch of the CAC you didn't have is now going to come in. That was the basis for the original investigation, and it was in discovery from the beginning of the
Is there
case.
some reason why the state didn't notify the defendant earlier in the game that, yes, we plan to use it?
I think motions in limine are filed when we actually know the case is going to go to trial. I will say, I was the one who filed it a few days before, and not to play tit for tat, but I know that the defense counsel also filed motions in limine right before the trial happened. And just so if it matters to the court for best practice, it's now in share file every time a case is approved an indictment to try to avoid this issue. But I don't think there is any time constraint about motions in limine. Those come up when the case is going to trial.
I'm going to ask Attorney McNamara in just a moment that if the video came in under the previously existing jurisprudence, what about that specifically prejudiced his client? You won't have a chance for rebuttal on that. Can you anticipate what he might say and say, no, he would not have been prejudiced if it came in simply under the previously existing jurisprudence?
He wouldn't have been prejudiced because, as the court mentioned earlier, I think Chief Justice Stanfill, prior to the trial, when the state was prepping its witness, there were some Brady-Giglio issues because of lack of memory. And I know the memory is a fickle thing. My rebuttal has made everybody upset. But when you look at that, when it comes to prejudice, they were on notice that there were some things that were inconsistent within that. So say for a recorded recollection under State v. Adams, say she had forgotten more things and she couldn't remember and the CAC came in. On cross-examination, you still have the ability to challenge the fact that she couldn't remember, that she didn't understand what was happening. And that's exactly what happened here. To go back to the confrontation issue a little bit as well, I think what's very distinct and unique about this statute, and I did do a long string cite in my brief, and I apologize in advance, not really, it was fun to do. But I did a lot of research about other states, and our statute is very conservative compared to other states. In some states, the child is in a different building, they don't even see the defendant, and they are through one or two-way screens. In this case, the victim had to walk in, she was subject to a direct, how minimal or robust it was, and she was subject to cross-examination. And the defense counsel was able to cross her not only on the Brady-Giglio letters that had been provided, but also from the CAC video. He was able to question her memory. And despite how my rebuttal, I thought, went, the state didn't win on all of the charges in this case.
But in other states, there are certain limitations on the use of that broader video. You have to show, for example, a specific harm to the child in that particular case, while here it comes in automatically. And I guess my abstract question is, does the looming change in the rule of evidence, should that be a factor considered when determining whether there's been prejudice under the Speedy Trial Act?
So I have two slight answers to that, and I know I have the yellow light. But one thing I will say about the statute is that it does require a motion in limine. So the CAC has to go through a rigorous evaluation by the court. And in our particular case, and when it comes to prejudice, the idea that they weren't aware of how it was going to come in or on what foundation it would come in, as defense counsel, there is still, and as the state, we could have had a situation where they brought the CAC in to show prior inconsistent statements. There has to be some level of preparation to understand that in a trial, you never know exactly how it's going to go. But in this case, what is great about this statute is before trial, both parties know what the CAC is going to say. In many ways, it's a benefit to both. Thank you for your time.
Thank you. Mr. McNamara.
Thank you. I'll begin with Justice Mead's question. It's very important for the jury to see how that direct will develop. In the example of the Adams case, there was considerable testimony to the effect that the complainant in that case could not, and this is required for recorded recollection, could not adequately recall what had happened. And it's important for the jury to see that on the stand.
On direct?
On direct exam.
And then they're impeached with the video after the fact.
They're impeached after.
What happened here, this was front-loaded with the videos, so that was all out there.
Correct.
And that's the prejudice?
That's part of the prejudice. The complainant isn't even in the courtroom when the video is displayed. So the jury is not able to see her reactions that might be happening as that's going on. Also, in addition to that, in this case, the uncharged conduct that comes in under this CAC statute. Justice Murphy said it's about 50% of the allegations in this case was uncharged conduct. I'm not sure how that comes in without a direct testimony under other hearsay examples to that effect. I want to go to Justice Connor's point about, which I think is a good one, about other states having requirements of certain findings. This case, this court in the Twist decision said, we will approve under the federal constitution, but also we see no reason to have a different conclusion under the state constitution, which is telling. If there is severe psychological and emotional damage threatened to a child, then we will relax these requirements. There's no finding here at all, of course, in this case, nor is there one required by the statute.
You indicated that the child is not present when the interview is played.
In both the cases.
Could they have asked for the child to be present?
They probably could have. They probably could have. I don't know how that would have shaken out. The problem in this case, in this case, was that it actually came in through the CAC interviewer rather than the child, and there's supposed to be sequestration of witnesses, so there's some difficulty there in doing that. Your Honor made a point in the first argument about common law, about affidavits, and whether a child was competent to testify. I think it's important to remember that in many conceptions, including some at common law, of what a child was, that cut off at age 12. So in other words, age 12 is an important part of that. Also, again, I will question whether that is accepted practice in the law court since 1820 when we have adopted the Confrontation Clause that we now have. And that's all I have for a presentation, unless there are any questions.
8, 7.
All right, there, I take that as none. Thank you.
Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. As is also our usual practice, Ms. Flaherty, somehow this is your first argument here, other than the high school, so we would ask if you wish counsel to come back and take the greetings of the court.